2022 Annual Report of the Intellectual Property Tribunal of the Supreme People's Court. Overview. In 2022, the Intellectual Property Tribunal of the Supreme People's Court accepted 6,183 cases involving IPR litigations, involving technologies and monopoly appeals, marking an increase of 18% compared with the same period in 2021. 3,468 cases were concluded, with 2,014 maintaining the original judgment, and 18.1%, 7.7%, 0.5%, and 13% of the total were closed through withdrawal, mediation, remand of retrial, and a change of judgment, respectively. In 2022, the court received 457 new cases involving foreign countries and Hong Kong, Macau, and Taiwan, accounting for 10.4% of the total, marking a year-on-year increase of 4.6%. Examination period, year-on-year growth. The average trial period for various types of cases is 165.2 calendar days. Among them, the average trial period for jurisdictional cases is 28.6 calendar days, 179 calendar days for civil cases of second instance, and 215 calendar days for administrative cases of second instance. Data on cases of different kinds. 2,956 new civil cases of second instance were received, marking a year-on-year increase of 15.1% and constant growth for 4 consecutive years. Among them, there were 615 disputes over infringement of invention patent rights, marking a year-on-year increase of 6.8%, and 968 disputes over infringement of utility model patent rights. All combined, they accounted for 53.5% of civil cases, marking an increase of 14.5% compared to 2021. There were 312 disputes over patent application rights and patent ownership, marking a year-on-year increase of 88.7%. There were 78 disputes over technical secrets and 648 computer software disputes, marking a year-on-year increase of 9.3%. There were 96 technical intellectual property contract disputes. 887 administrative cases of second instance were accepted, marking a year-on-year decrease of 403 cases. Among them, there were 241 administrative disputes over re-examination on rejection of invention patent applications, marking a year-on-year decrease of 47.3%. 234 administrative disputes over invalidation of invention patent rights, marking a year-on-year decrease of 17.3%. 27 administrative disputes over re-examination on rejection of utility model patent applications, marking a year-on-year decrease of 25%. 207 administrative disputes over the invalidation of utility model patent rights, marking a year-on-year decrease of 11.5%. 84 administrative disputes over invalidation of design patent rights. 3 administrative disputes over new plant varieties, and 2 administrative disputes over integrated circuit layout design, which was the first time the court accepted administrative disputes over integrated circuit layout design. Monopoly cases. In 2022, a total of 83 monopoly cases were accepted. Among them, 47 were new monopoly cases of second instance. 57 have been concluded, with multiple cases having typical significance and significant social impact. Cases of new plant varieties. 1. The number of cases involving disputes over the rights of new plant varieties continues to grow, and there is a significant increase in disputes over the rights of economic and ornamental crop varieties. In 2022, 144 disputes over the right to new plant species were accepted, marking an increase of 112.7% compared to 2021. 2. The variety rights holders litigation and rights protection paths were diversified, and the types of infringement entities became complex. There was also increasing difficulty in balancing interests, and there were new changes in the entities of responsibility and the concealment of infringement behavior. Data on cases involving strategic emerging industries. In 2022, there were 1,338 new cases involving strategic emerging industries, accounting for 30.4% of the total, marking an increase of 3.5 percentage points compared to 2021. There has been a significant increase in cases involving new industries and fields such as next-generation information technology, biopharmaceuticals, high-end equipment manufacturing, and standard essential patents. The stress of judicial protection was conspicuous. In the two cases concerning the secret infringement of melanin patent and technology, a compensation of RMB 218 million was awarded, signifying the stress of judicial protection and equal treatment of various enterprises.